When bringing a medical malpractice lawsuit, if your doctor's office loses your MRI scans, your CAT scans, your nuclear stress scans, can you go ahead and get a judgment against the doctor because they lost your records? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The answer in New York is no, you can't. A doctor is required to keep your medical records for a certain period of time. And in order to bring your medical malpractice case, we have to obtain all of your medical records. We then have to get all of your records reviewed by a qualified medical expert. Only after he determines that, number one, there was carelessness, number two, that the carelessness was a cause of your injury, and number three, that your injuries are significant or permanent, only then are we permitted by law to bring a lawsuit on your behalf. So now people have come to us and said, listen, my doctor's office can't find those records. What do I do? Well, now we are at a significant disadvantage because now we may have difficulty proving that you are more likely right than wrong, that what you are claiming is true, that your doctor was careless. In that instance, how do you go forward? How do you go ahead and show that your doctor was careless if your medical expert cannot review those records? Well, that's going to be a significant challenge. In law, there's something called a spoliation request. Now, what does that mean? Well, it means that the doctor is required to keep certain records for a period of time. If he fails to do that, now we can ask the court for what's known as a spoliation charge or a spoliation order. Now, what does all that mean? It means that the judge recognizes that this doctor had an obligation to keep your records, and for whatever reason, he failed to do so. Now we're asking the judge to hold it against the doctor, because now it makes it that much harder for us to be able to show that you are more likely right than wrong, that there were violations from the basic standards of medical care. So in some instances, a judge may turn around and say, hey, doctor, you didn't do what you were supposed to do, and now when your case goes to trial, the plaintiff's attorney, the injured patient, and their attorney are going to be able to use that evidence that you failed to keep this evidence in your control, these documents, these records, these CAT scans or MRIs. And because of that, the jury will now be able to infer that there was something damaging in that information, and now the jury can use that against you to find that you are legally at fault for causing this patient's injuries. That's a very powerful thing. Now contrast that to what I asked in the headline of this video. In this video I said, can you get a judgment or a directed verdict against the doctor that you are suing if they fail to keep your records? The answer is no. This exact scenario came up not that long ago, and a trial judge said, hey, yes, injured patient, yes, you are going to get a judgment against the doctor. For what? For failing to keep those records which he is obligated to keep. The defense didn't like that, so they went ahead and they appealed it to the appellate division. The appellate division said, no, no, no. You cannot give the patient a judgment for them at this point. Instead, you can go ahead and when they get to trial, now the jury will be told what it means to spoil this evidence, and now they can use it to infer that everything that was in those documents or those scans were favorable to the patient, which means it would have been harmful to the doctor. And they can use that to find fault with the doctor and give a verdict to the injured patient. So why do I share this great information with you? I share it with you just to give you an inside look at what happens when a doctor's office or a hospital fails to keep in control medical records, scans, things that you will need in order to help show that you are more likely right than wrong. You know, I realize you're watching this video because you have questions or concerns about your own matter. Well, if your matter happened here in New York and you're thinking about bringing a lawsuit, but haven't done so yet because you still have questions that need to be answered, what I encourage you to do is pick up the phone and call me. I can answer your questions. You know, this is something I do every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.